How do?
Nice to meet you. So I'm with Larry Haskell. He's the two-time incumbent for the Spokane County Prosecutor's Office. Larry, why don't you tell people a little bit about yourself and what you've done over the last 8 years as prosecutor?
Sure. Well, I had a whole career in the military, nearly a whole career in the military before I even went to law school. And then in 1994, I went to law school, graduated in 97, and when I passed the bar, I got offered a job here in Spokane in May of 1998. I was a deputy prosecutor up until 2002 when I went back on active duty for 3 years, post 9/11. And when I came back in 2005, again, a deputy prosecuting attorney, and then I ended up doing some time as an AUSA. And then when I came back shortly after that, it was election time, and I'd already been on the Airway Heights City Council for several terms and also the Cheney School Board. So I wasn't new to holding elected office, but the first time I took a county-wide race was in 2014.
Wow. And so when you went back into the military in 2002, in what capacity did you serve?
Well, I'd been a prior pilot in the Air Force.
Wow.
So what they did was they used my flying experience and they put me in something called the Air Operations Center, which was in the middle of the desert of Saudi Arabia. And we prosecuted the war in Iraq primarily. If it was flying, it was controlled by our agency in the desert.
Wow, so you were essentially an air traffic controller for the military.
Well,
is that kind of a rudimentary way of saying that?
A little bit. What I would specifically do is, for most of the war that for which I was there, I would get requests for assistance from ground troops. We would look for a suitable airplane with the right bombs. We would direct it to a tanker, and then eventually we would direct it to somebody who would control the aircraft for the group on the ground that needed the close air support.
Wow. Well, thank you for your service. I think it's fantastic. So let's get right into it. There's a little bit of controversy that's kind of been following you around, and you've probably answered this question a million times. So your wife said something distasteful on social media, excuse me, and it's kind of been painted as though you've said it, and there's a perception in the household, I think, that when one person says something or one person holds a certain belief, that their spouse must believe that and their spouse must be this. And I think that you're held to a higher standard, even more so when you hold elected office. So your wife said the N-word directed to Joy Reid, sorry. I don't know where I got Mayor from. Joy Reid. And it came back and it's just really been used as a tool against you. And I want to preface this with saying my wife is black, and she and I have talked about this issue, and we've talked about this before. And we are firm believers that you as an individual should not be held accountable for the actions of someone else, whether it's your wife, your son, your daughter. We don't prosecute people in the United States or in any Western world. We don't punish the child for the sins of the father. We don't punish the father for the sins of the child. If we did, we'd all be in prison because everyone's done something in their life that was probably seen as unspeakable. Now, that isn't me condoning what your wife said, but what I would say is that I do believe, and my wife holds the same belief, we were just chatting about this last night, that people often say things out of anger that they don't necessarily mean, and it doesn't necessarily mean that your wife is racist, and while we don't condone it in any way, she shouldn't have said it. It wasn't right in any way, shape, or form, no matter who it was directed toward. That we firmly believe that these are the issues and the contentiousness that brings division in our society, where instead of just being able to deal with that one instance of racism and allow for room for forgiveness for someone who has said something they ought not to, we are in a society now where it's like, nope, you said that thing, you are that thing, and you are that thing now forever and always, amen. And we just don't prescribe to that in my household. My wife has seen true racism on both sides. She is half white, half black, and she's seen it from both sides. All throughout her high school, she saw it. And we really, this is something obviously we care about, and we're really passionate about, and we have just really understood that that there is no such thing as institutional racism, and that true racism in the form that we are taught what racism is just it truly doesn't exist, and that's a personal belief. But again, not giving light to or playing light on what your wife had said. But I do want to iterate just from our perspective that we know you didn't say that, and we feel that it's unfair and unjust that you're being held accountable for someone else's actions. So I just wanted to get that out and just let you know. I know you weren't aware that my wife was Black before we had this conversation, and I didn't want to blindside you and just kind of pin you in a corner, because that's not what we do. And that's just not who we are as Christians. So I want you to know that my wife and I have talked about this. We talk about who I interview all the time, and it isn't her position to cast judgment on your wife. And while what she said was not good, that it wasn't you that said it. So just to put that out there and to make that clear that we are here to talk about substance. We're here to talk about issues. We're here to talk about your position and how you've performed in that position and how you're going to continue to perform in the issues that are facing you in that elected office. So I just wanted to let you know that.
Thank you.
Yeah. And but to that point, I'm not going to keep hammering it home. Larry has unequivocally renounced the things that his wife has said. Correct. You have publicly stated that it is not good and so on. So we don't need to get into that whole thing. That's not why we're here. So with that said, and my monologue over, let's get into the survey. So you did respond to our survey, the judicial candidate survey, it is the prosecutor survey also. And so we're just going to jump into the issue of liberty. Okay. So on question 1 of the judicial candidate survey for Larry Haskell, we have liberty. Public health situations such as those that occurred with COVID-19 do not justify the imposition of restrictions that infringe on citizens' constitutional and personal freedoms. You responded to 10 strongly agree, and you said both federal and state government appeared to value power and control over protecting rights, and especially as measured against low infection and mortality rates. The effects on rights, the economy, and mental health were ignored. And so this must be really frustrating for you as someone who is told to or instructed to, by nature of your job, prosecute those who ignore the law and ignore our constitutional rights. And now you're being told, well, you don't have your constitutional right. So this must have been really frustrating from you from that perspective.
Oh, no question about it. And the invocation of the emergency powers assumed by the governor that were granted by a legislature a long time ago, not being able to foresee the likes of a COVID-19 situation. Even the legislature, many members, particularly from our area here in a more conservative area, were very distraught over the use and some would have called it the abuse of the emergency authority. As far as I know, the governor still has retained his emergency powers, and the pandemic, at least outwardly, is over. And there are people that are getting COVID, and it doesn't seem to matter whether you have 2 shots and a booster or 2 shots and 2 boosters, and you're wearing a mask. If you're going to get COVID, you're going to get COVID. So I do feel very strongly about the fact that we quarantine the sick, not the healthy. And the fact is that there were a lot of other factors, and they kept saying, follow the science. But the science wasn't supporting their position that they took and the drastic measures that they put into place. And eventually, the science actually showed that a lot of that was actually ineffective.
Well, and it's even if the science was there, it doesn't give the governor the right to violate our constitutional rights.
Precisely.
Right. So it's like kind of a two-pronged thing. It's like, allow people to make the decisions that are safe for them without infringing on their constitutional rights and freedoms. And so people say, well, the government stopped us from working, but then they compensated us for it, so it's okay. It's like, no. my wife, when she stopped working, look, fortunately, I'm an accountant. I can work from home. The amount that she received was nowhere close to what she would have been able to produce had she actually been working. So it doesn't give justification to shutting down the entire country, which wasn't him, but even then, our entire state.
Well, and not only that, that comment about, but they compensated us. Well,
Right.
The fact of the matter is I met on several Zoom meetings with local small business leaders throughout that very time period, and they were drying up, and what they had worked their whole lives to build, and modest in most cases at that, they were losing. Look at all the businesses that are no longer with us. I don't need to look any further than Timber Creek over here, right?
Yeah.
A business that was running very healthy, and COVID shut it down. And there were many others in the same position where they'd worked their whole lives and invested not only all their labor but all their assets and other resources. Yep. And because of this issue, where way over the top in terms of the authority from the Constitution, as far as I'm concerned, yep. we are a free people. And we should have been free to make our own choices during this time.
Amen. Yeah, I mean, it's abhorrent to think that, I'm British, so I come from a country that is free, but it's not free. So we don't have the right to freedom that we have in the United States. And so when you come here and you live that freedom and you understand the beauty of the Constitution and the beauty of the country itself, you start to reflect on things where you think, well, I was free, but it's like, but were you free? You weren't really free, right? So, and I think that when I start seeing from an outward perspective, not an outward perspective, but when I start seeing the government start to impose in our individual rights and freedoms, and I just look at that and I go, man, this is dangerous territory. And, you don't have to be a constitutional scholar or a lawyer or anything else to see that. You just need to understand the true meaning of liberty to know that the government violated our rights like over and over and over again, many times over. And like you touched on that, Jay Inslee's, he still has his emergency power, and what are we, 800 plus days now or something? I mean,
I remember one of his first speeches. He said, "Wear a mask for 2 weeks. We flatten the curve, and we're out of this thing."
Which was the national narrative, and never happened.
Yeah, no.
And the issue is that then if you go against him, you have no power because he just shuts you down, and it's just, man, I could go on for days. But from a prosecutorial standpoint, I mean, did you see any direct correlation to it lowering crime rates, lowering prosecuting rates during the period of COVID? Was there less crime? Was there less prosecution?
Not in my view. What we were seeing, because businesses were closed and nobody was there manning the ship, if you will, we saw increased numbers of commercial burglaries, because of the fact that they knew that people weren't there, and we didn't see the same correlation between private residences, but the commercial burglaries were definitely up. And of course, from the governor on down, the big push was to get DOC persons out of prison.
Right.
And we had several big swaths of people that got out, and the same thing was happening in the county jail. So they were emptying the jail to try to be able to social distance and quarantine people when they came in, and they had COVID or they contracted it while they were there, and that put people that we don't put that many people in jail already. So when you're emptying the jail because of essentially what's going on, in the governor's mansion and the edicts that were coming out of there, we're putting people that would have otherwise been in jail out on the street, and predictably, some of those are committing additional crimes. And statistically, people commit 6 or 7 of those types of crimes before they're caught. Much less prosecuted and actually held accountable, because many a time I've sat in a courtroom when a person said, "This was the first time I've ever done this, Judge," and the judge interrupts and says, "No, this was the first time you were caught."
Yeah, I've heard that too, and it's the problem that we're facing in Spokane County now is homelessness is one of the biggest issues. Substance abuse, homelessness, and mental health issues for the homeless that are on the streets. So, how hard is it now for you to prosecute people who have substance abuse issues or homeless? Have the state made it hard for you from a legal standpoint to prosecute?
One of the most significant decisions that's come down from the state Supreme Court of late is the Blake decision. And in that case, it was a Spokane County case. And the defendant in the case, Miss Blake, elected to do a bench trial, and she brought the unwitting possession defense, as we call it. Mm-hmm. And the judge didn't believe it, and she was convicted. It worked its way up through the court system. State Supreme Court declared that the possessory statute for Washington for straight possession, not delivery or possession with intent, but just the possession statute was unconstitutional. So the legislature eventually responded, and they made it a misdemeanor. They didn't decriminalize it, and it's on a 2-year pilot right now. But what they did do was they mandated diversion by the police through educational pamphlets, information on how to get treatment if you want it, and that sort of thing. And what the police have been telling me is a block from where they gave it, they'll find it on the sidewalk. So not very effective. And further, the legislature highly encourages prosecutors to not prosecute even subsequent violations of the Controlled Substances Act. Now, they still they didn't declare them legal, so police still confiscate drugs when they find it, but we don't prosecute except in the most extraordinary of circumstances.
So as the law is currently written, could you just explain a little bit? Because I've read it and it seems like it's almost like a catch and release law. And you're saying it's not even that. It's just, here's a pamphlet, let me take your drugs and see you later.
Yeah, you're not catching. You're talking to them, and you confiscate the drugs because they weren't declared legal. And then you give them educational information, treatment options, and that sort of thing. And that we have to be able to show, if we did choose to prosecute a subsequent offense, we have to show that they were given a diversion opportunity at least 2 times.
So how do law enforcement, I know you're not law enforcement, but how do law enforcement document that? So if a case comes before you and they say, hey, Larry, we've talked to this guy several times, more than 2. We've talked to him several times. What proof do you need that they've done that in order for you to move forward to prosecute?
We need to be able to have an incident number and a brief description to be able to satisfy the requirement, because otherwise you would be violating the statute if you prosecuted. And it's kind of like certain cases, you need to show certain prerequisites. To get a felony violation of a domestic violence, no contact order, you got to show a couple of priors, same thing with some other types of offenses. 3 strikes, for instance, you got to prove that in those cases, beyond a reasonable doubt, that this person that's sitting in this courtroom that was just convicted of the 3rd strike was in fact convicted in these 2 other instances of a strike offense. So it just becomes another element. We haven't run into a case yet that I'm aware of. It would land in my district court if it did, but they would have to show the 2 prior diversions.
Okay, so what would be stopping the person who gets pulled over from just saying, he never pulled me over? He never stopped me.
The police officer's going to make a record of it.
Right, but I'm playing devil's advocate here.
Sure.
I just say, that wasn't me he stopped. Someone else gave my name.
Yeah. Well, the court, I guess, in the end would have to make a decision on that.
Right. Yeah. And it just lends so much ambiguity to lends ambiguity to the law, because it's like, well, now the police officer feels like, well, what's the point in even talking to him, because I'm going to talk to this guy. Oftentimes you've seen him 10, 15, 20 times, maybe even arrested him that many times for the same issue over a span of years. And so the police officer already knows that this person is visibly, you could see they're intoxicated, and then you give them this pamphlet. And, the police officer has seen that they've been through the system. We know they've been through the system based on their record. How is this helping the people on the street that are living these lives?
Well, I don't believe that it is, because one of the things that the previous manner in which we did it, options open up, and now the option for the police, it's mandated by the legislature that they hand over the informational materials, and they don't arrest, they don't book, or especially on the first two. But even after that, like I said, prosecution is discouraged by the legislature. So, but even at that, for instance, options that we used to pursue, for instance, drug court and the therapeutic courts in general, even mental health, are voluntary. And so, if there's nothing, so-called hanging over their head, a penalty of some kind, for some, they'll never voluntarily do it. Others will, but I think it's fewer in number since the Blake decision that are opting to go into drug treatment. Is not easy. Drug court is not easy. It's a year long. It's regimented. There's random UAs. There's classes to attend, and it takes a year. So it takes a little discipline, and you really got to kind of want it, and a lot of them do not.
That's the case. You gotta want it. My wife's brother is, and I've said this a few times in interviews, so sorry to the voters who have to hear me say this over and over again, but my wife's brother's on the street. He actually, no, he's in county jail right now, picked up on probation violation, is a drug addict, has been for many years, and we absolutely love him to pieces, but at the end of the day, we've tried to help him so many times, and it's at some point, it's like, hey, you have to want this. We've taken him to Teen Challenge, taken him to UGM, worked with his POs, given him a place to stay, and eventually my wife and I had a conversation, it's like, we can't help you anymore. I'm sorry. We are not able to provide the help you need. And you need to want the help that you need in order for you to get clean. I truly fundamentally believe that in what I've seen. My wife's sister passed away 2 years ago. We don't know what the overdose was. We think that it was heroin, but we're not sure. But she overdosed in Seattle, and my wife gets a call in the middle of the night, next to kin, hey, your sister's in hospital, and she was without oxygen for 10 minutes. So 3 weeks back and forth to Seattle, and the impact that this has in the community at large, and I'm not even talking about a monetary impact. I'm talking about the families that we have to, that have to go through this, and the impact it has, and the lack of personal responsibility on the individual's part. And then you have a legislature saying, hey, don't prosecute them because they didn't do anything wrong. Well, yes, they did. They broke a ton of laws, and they're walking around the streets intoxicated, defecating everywhere, peeing in doorways of businesses, sleeping in doorways of businesses. If I did that, I'm sure I'd be moved along and either given a ticket and or arrested. So why are we now giving privilege to people who have zero personal responsibility?
Well, the courts didn't help us as far as that goes in the area of treatment. So what we've had to do, and we're in the process of working with the drug court and the mental health court, and we're trying to retool them a little bit so that they'll be able to take people with co-occurring disorders. It's substance abuse disorder. Mm-hmm. It's a DSM now.
I got to interject there.
Sure.
Substance abuse is not a disability. It is a life choice someone made that is hard to get through. That is hard, and this is very personal to me for multiple reasons. But it is a life choice. Someone at some point decided to make a choice to take a substance, and has then as such been dependent on that substance. That is not a disability. People don't choose disabilities. This is a very, very important distinction, because we say, oh, they're disabled. I'm sorry, you're not disabled. If you are a drug addict or you're an alcoholic, you are not disabled. You have a substance abuse issue. You need counseling. You need abstinence. You need discipline. These are the things you need. Not Social Security disability checks that just encourage this behavior. My wife's ex-husband was an alcoholic, very abusive to her, and he went and sued Social Security, and they labeled him disability, gave him a huge settlement, and said, off you go, here's a check for the rest of your life. Now, how is that fair to people who work day in, day out, and have disabilities or are fighting for that disability check when they're truly disabled. And we're saying, well, substance abuse is a disability. And this is more of a moral question than it is a prosecutorial question.
Right.
And I just think that it's 20 years ago, if you told someone being an alcoholic is a disability, they'd say, no, let's get back to reality. This isn't a disability. He's choosing that action. Where, and this is, again, it's a moral question, not a prosecutorial question.
Right.
But why have we let this go, even especially from a legal standpoint? Why have we let this go so far to where now prosecutors are standing up and saying, well, he has a disability, instead of saying he has a substance abuse issue and he needs mental health treatment, or he needs long-term treatment to get through this, and so on.
Right. And we do everything we can within the tools that the legislature gives us to be able to encourage and coax people into those treatment programs. And that's part of what we've been doing and working with the Criminal Justice Treatment Account. I sit on a board and we make decisions regarding funding and how to move money to where it can be more effective, or the most effective use of the money that we're given for purposes of getting people with addictions and less than a hospitalization level of mental health issues as far as that goes. So that's what we try to do within the means that we're given.
I just want to clarify something. I have strong opinions about this, but don't get me wrong. I know that it is hard for people. I've seen my brother-in-law struggle, and I truly believe that when he's sober and he has a clear mind and he has these goals, I truly believe he wants those things.
Yeah.
He just has this grip, this devil that's gripping him,
Yes.
and it's pulling him down. And so I'm not saying that these people don't need help. I'm not saying that I'm not compassionate. I am compassionate. What I'm saying is that giving people a way out by saying, oh, it's okay, you're just disabled, is not compassionate. It is not compassionate to those people. These people, they need help. They need strict help. They need long-term help, not 90-day, not 60 days, not 90-day programs. They need to be assigned to a long-term program like UGM, like Teen Challenge, like the Ranch. They need to go to these programs and they need to work through their issues. These 60 days and 90-day programs, they don't have enough time to get to the root cause of the issues. Often it's trauma, abuse,
Right.
and we know this. And it's not that we don't care, but it's, hey, we know these things. Bad things have happened to me in life, happened to you in life. You've seen bad, you've seen evil. But at the end of the day, if you let those things define who you are, the impact is, and the implication of that is so much more. And we're seeing that now when you feel like, now it's harder for you, not you feel like, but that it's harder for you to prosecute people who are breaking the law because they have a substance abuse issue, because we're saying, well, hey, maybe we ought not prosecute them because they have a disability. It's like, so if a disabled person who is wheelchair bound rides down the street and is shooting at people, are we not going to prosecute them? Having a disability isn't an excuse to not enforce the law.
Well, there was one time when I was having a kind of an off-the-record, this was years ago, and the judge is not on there anymore, but I had an off-the-record conversation with a relative of a Court of Appeals judge who said that, in his view, drug addiction was a public health issue for possession, but it's not a prosecution issue unless it's a delivery.
I don't agree with that.
Yeah,
I don't agree with that because
but it's indicative of the current feelings of the courts and also the legislature. And it would take, and we can get into this subject because I think it's really, really pertinent to this particular election. With what's going on not only nationally but statewide in terms of trends. And that is taking tools away from police and taking tools away from prosecutors to be able to deal and assist those through prosecution who refuse or are unable to help themselves Man, I mean, I made pronouncements when I was running back in 2014. I said, if you have a drug addiction issue and you can't keep out of your neighbor's garage or the house down the street or the local business that's closed due to COVID or whatever, then I have a duty to this public to protect them from you. And if that means you're going to get your treatment in the Department of Corrections where you have nothing else to do but try to get yourself better, then that's what we're going to do.
Yeah. And that's the sad thing is so when my wife's brother, he got out of prison last time, he said, hey, because you need a release address. And he said, hey, can I come stay with you guys and use your house as a release address? And we were like, no. You're not using our house is not a halfway house. You if you're not living here, then no. I said my wife and I talked about it, and it was a consensual. That we came to consensus that he could stay with us temporarily when he got out, so that he could then enroll himself into Teen Challenge. Mm-hmm. And we worked with his DOC officer, and we didn't work directly with the judge, but the DOC officer did on his and our behalf, because he swore up and down he wanted to go to Teen Challenge. And he did. He went to Teen Challenge, and we went and bought him all of his necessities and clothing and so on. And we took him to Teen Challenge. He's there for 2 weeks and he leaves. And you have no power. And then it was like my wife and I sat down. My wife is very disappointed because she had just lost her sister, and she was just a mess in terms of now she's thinking I'm going to have the same phone call with my brother, and it's the sad reality is it's a matter of time unless he makes the decision to get clean. It is a matter of time. And so this is not something that we take lightly, but at the end of the day, I agree with you. If he is walking the streets and he has methamphetamine, heroin, fentanyl in his pocket, and the police stop him, he should be arrested and he should be prosecuted to the full extent of the law. I would be, and I would expect that I would be, because it's not okay. And the reality is that we are allowing feelings. You brought it up. The feeling of the legislator is that we ought not do this, but the law is the law.
Yeah, and that's why they've changed the law. So the court responded, and then the legislature responded, and they kind of went in their own way, the same way as the courts. The fact of the matter is that the legislature is creating an atmosphere in the state that lawlessness is okay.
Yep.
And it is not okay with this public, and it is not okay with me and the people that work for me, who are charged with the responsibility for creating less victims and holding offenders accountable. And at the same time, we're trying to do that. It feels like the legislature, the majority, at least in the legislature, because there's a significant minority vote against a lot of this stuff too. So we need to point that out to be fair.
There are people that are standing for truth and law and order in the legislature,
Correct.
And that is very important to point out. So you said something earlier that was kind of telling. You said, so the law is the law. They changed the law. Okay, that's fine. But then you still say that, well, the legislature, they really dissuade you. They really want you not to prosecute,
Correct.
even when it gets to that point.
Correct.
So is there a pressure, do you feel, when you you get a person in front of you that you legally can prosecute, you have ample evidence and so on, and you want to prosecute them? What is it like when do you doubt whether you ought to prosecute them or not at that point?
No, I don't doubt it. We have to be able to show those two mandatory diverts that I talked to you about. But other than that, the legislature has left it open, but encouraged to not prosecute. I don't feel any pressure. But what we would need for it is facts and circumstances and admissible evidence and that sort of thing in order to do it, and would more likely, if they were willing, avail themselves of one of those treatment options. But like you said, it's very hard. You've experienced it in your own family, and one of the most refreshing moments I ever had as the prosecutor was one time when I was manning a booth, and a gentleman kind of circled a couple of 2-3 times. I could tell he was building up the nerve to come over, and he came over and he shared a story with me, and he told me, he says, all the coaxing in the world and all the treatment options in the world didn't do anything for me until I bottomed out. Mm-hmm. And he said at some point in his life, he reached the point where he was tired of being in jail. He was tired of being in prison. He was tired of owing fines, fees, and costs to the court. He was tired of being on probation and having to report. And one day he woke up and said, done. I'm done. I can't live like that anymore. He told me he got a job at a local business. He's not making a lot of money, but he's free. Yeah. He's free of the substance issues, and he's free of all of the things that come along with it, and especially if you choose the prosecution route and not take treatment. For offenders that are only addicts, we want them to take treatment. If you have a mental health issue, we want you to take steps to take care of it. And those resources are out there. In some respects, they've never been better. But not everybody chooses to avail of themselves. So, and it's not 100% of drug addicts and people with mental health issues that are committing crimes. It's a small percentage. There's a lot of people out there with issues, drug and mental health, or sometimes both, that are not committing crimes.
Right.
But if you choose to commit crimes in my community, then I have a duty to the people who live here, their safety, their property, their children.
Yeah.
And I'm going to do what the law allows me to do in those instances. And like I said, I've told people, if DOC is the only place you can be to work on this issue, then that's where I'm going to see you try to be.
Yeah. So what do we do with repeat offenders that continuously violate probation? Do you have any say in how those cases move forward?
Well, okay, so probation is post-conviction, and the programming in post-conviction world is run by the Department of Corrections.
Got it.
And then they will set up, for those that they determine are actually going to be on community custody. So a judge may order it, but that doesn't necessarily mean that they're going to be on community custody, because after they leave the court, the judgment and sentence goes out to the department with them. They run a risk needs assessment on their own, and they make a determination what, if any, community custody someone's actually going to have, and then they control the process. They can give administrative sanctions and that sort of thing, and some jail time and that sort of thing without actually going to a court in many instances.
And is it would be the DOC then that would then issue a warrant, and then they would issue the warrant for a violation, repeat violation, and so on. And then does it come full circle then? So let's say that the DOC picks someone up for repeat violation of probation for whatever reason. And the ramifications of such as prison, you go to prison for 2 years or whatever. Does it have to come back to you, or is that considered the same part of the same conviction from earlier?
If it's just community custody violations that are imposed by the department, usually they're going to handle that. Now, if they abscond or they don't show up, and the DOC officer can't get in touch with them, that sort of thing, then they can come to us, and we'll work with one of the local police agencies, and they'll draw up a charge request for escape from community custody, and that's where we would get involved again. Okay. But typically, the administrative side of the department, when they're on community custody, is outside of our office.
So it's essentially, you prosecute essentially, I would say, I guess you'd say fresh crime. So it's
it'd be a new crime.
New crime right off the street. Okay,
yeah.
That makes sense. And the reason I ask this is because I think that there's a lot of nuance isn't the word, but there's a lot of there's a big system, and it's really hard, I think, from it. Now, I try to ask questions that I think people want to understand. Well, how does this work, right? And I think there's a misunderstanding about how the system works and how people get pushed through, and then how probation works and so on. And really, it was from my understanding to say, okay, now it makes sense. So you're prosecuting only new crimes, and so just thank you for the clarity, because it helps me to understand, and I think that people will have a greater understanding of it. I'm not an attorney, I'm not a legal scholar, so it helps me tremendously understanding what it is that and how it is that your office functions. So. The founding fathers framed the Constitution on biblical principles, and right now in today's world we have this pushback against holding even a religious worldview, whether it's Christianity, Muslim, or any other out there. But we've allowed for other small secular groups to come in and essentially impose their worldviews on us while we're sitting back. And this is a moral question, not a legal question. That impose their worldviews upon us while saying, well, you can't impose your worldview on us. How hard is that for you to see from the community that you've been in for so long? It wasn't like that in 2008 when I moved to the States. It just seems like over the last 4 years, there's just been this really just degradation of social and cultural issues.
Yeah, there's no question about it, and the loss of a moral compass, which is usually grounded in religion. It isn't always grounded in religion, but it frequently is. It was certainly stronger when it was grounded in religion, but the secular worldview creates opportunity for a person who lacks a moral compass to be able to get into a position and exercise influence that has nothing to do with morals. When I look at the federal government right now, and I look at what's happening there, it comes to mind that the reason that the Constitution has worked so well so long is because it counts on the separation of powers and the integrity and the morality of the people that sit in those positions to be those kinds of people. It will not work well, and I think they're amply demonstrating that when you lose sight of those kinds of principles.
And so, how would we tackle? How do we tackle a culture that is getting further and further from the truths of reality? And they're saying, well, I can tell my child or my child thinks that they're a girl when they're a boy, and that's okay. And I can now take my child to have gender reassignment surgery, and I can essentially tell them it's okay to be a girl if you're a boy, and so on. I feel like 20 years ago, if I'm a parent and I'm telling my child that, hey, that is a boy, that, hey, you're, and they claim to want to be a girl, and I say, well, that's okay, you can be a girl. And I take that child and I continuously tell them over and over again, no, you're a girl, you're a girl, you're a girl, you're a girl. I feel like the state probably would have got involved and constituted that as abuse. And now it's like we have laws on the books that are saying, no, that's not abuse. It's okay. It's okay for children to tell their sons or daughter that they're a girl or a boy, rather than what they are grounded in science and in God. And so I guess the question is, have you seen a dip in these abuse cases where children maybe have been in these environments that were abusive? Because I personally believe that it's abuse to tell your child who is a boy that they're a girl. It's not rooted in science. It's not rooted in God. And we now have laws in the books that allow this. So has there been a trend where you've seen a dip in these cases? Do you handle cases like that?
I don't know what kind of case you're talking about.
So I'm saying specifically so 20 years ago, I'm trying to frame this in my mind the best way I can. 20 years ago, would a case have come before you if there was a child, let's say there was a boy, he's 5-6 years old, and he kept going to school and telling his teachers, hey, my mom keeps telling me I'm a girl. And then there's this continued trend. And then I feel as though, and I think that the school would have been like, hey, this isn't okay. Like, they're really telling this boy he's a girl. Right. And the CPS would get involved and so on. And I just, I guess I'm asking, do you view that as abuse? Do you think that in the legal parameters, 20 years ago versus now, would that have been abuse?
It could have been considered abuse 20, 25 years ago.
And now we're saying, hey, this isn't abuse.
Yeah. And what I find kind of ironic about that is we talk about juvenile brain science all the time.
Right.
And juvenile brain science is very much alive and well. It's accepted by the courts. And we actually have people resentenced if they were sentenced to really long sentences and they were under the age of 25. But what's really odd about it is there doesn't seem to be any consistency in the application of that except in the criminal world. And we have youngsters that can make decisions about their health and treatment, like 14 or maybe even younger years old. I know a 14-year-old can. So I don't understand how, for instance, a child who's 14 can make decisions regarding their treatment or walk away from treatment. But yet we're resentencing people for crimes that were committed, below the age of 25. So there's no consistency in it. And I've said to many people, I'll believe in the juvenile brain when it applies to all this stuff.
Yeah, because then the law would then have to state that you're not an adult till you're 25.
That's right.
So
no contracting at 18, no military service. You can't carry a gun. You can't enter into a contract to buy your favorite automobile because there's consequences associated with that. Marriage, you can be married and have several children before the age of 25, but yet you're not held accountable for criminal activity till, at about that time. So there's still consequences that they're ignoring. In other words, so it's all, I look at it as a criminal charge pass, if you will.
okay, so I guess give me an example of where in a case that you've seen this happen, where, so I'm just wrapping my head around this. So if you're 25 years old or younger, or younger than 25, okay, yeah. So you're 23 years old, you go out and you commit a crime. In what instance would they relook at that and go, well, he was a juvenile at that point, essentially?
Well, yeah, juvenile, subject to the juvenile brain science. So those are for really long sentences for the most part, but there is a requirement that judges consider factors of the juvenile brain when sentencing people under the age of 25.
I never heard this before. This is the first time I've heard it, so I'm trying to just wrap my head around it, because to me, I thought it was very clear that if you're under the age of 18, it goes to the juvenile court.
Oh, no, it can go to the adult court. It does go to the adult court at 18.
Okay.
Yeah. However, the court's required to consider the juvenile brain factors.
You might as well just give someone a pass for being immature. It sounds right.
Yeah.
I mean, honestly,
yeah.
That's what it sounds like.
Yeah.
Well, he was immature when he was 25, but he murdered 3 people because he was angry. So okay, but he murdered 3 people.
Yeah.
So he gets 50 years in prison, and so the judge then has to take that into account. Does this actually apply in the law, though? Do judges actually take this into account in practice? Does this work?
Increasingly.
Really?
Increasingly.
Do you have like a recent example of that?
Not with me,
right,
but I can get you one.
Yeah, I would be fascinated to see that,
sure.
and I'll post it with the video.
I'll get you the court case.
Yeah, that would be fantastic, because I'd love to post it in the description with the video, because
sure.
This is just, you've just opened a whole new perspective to me.
Yeah.
And wow, I'm actually flabbergasted, because I've heard of cases being where kids have committed crimes, violent crimes, even sometimes when they're 14, 15, typically never murder, but when they're 14, 15, 16, maybe they've really assaulted someone really bad, left them disabled, and then 20 years later you hear that they've had their sentence reduced, or they've been overturned and they've been let free because they were 14. And in that regard, it's like, okay, I can kind of see where they're going. They still committed a heinous crime. They spent 20 years in prison. And should you punish them for the, let's say they got a life sentence, for example. Should you truly punish them for the entirety of their life for that crime? Well, it's for me in my mind, it's like a two-pronged thing. It's like, yes, they were a juvenile, but the law is the law. So, the prosecutor and the judge did their jobs. And I suppose that it just comes down to me, then I think that, if I'm that victim's family, I don't know how I would feel. There are a lot of people that are compassionate and say, okay, I forgive you, and it's been 20 years, and if they can prove that they have changed, which I think is very difficult, but I can see that. But when you're 25 when you're 24 or you're 23, how do you get a pass then?
Yeah. I'll bring you the pronouncements from the state Supreme Court.
I would love to see that, and I'm going to post it, I think, with this video, because this is the first I've heard of this this juvenile brain. I think I have heard the concept before, but I thought it was specifically meant for juveniles under 18 years old.
No, not even.
Wow. So what are some of the struggles that you've faced during COVID, throughout COVID, and then now with rising crime rates and property crime throughout the roof? So what are some of the big struggles that you've seen in the past couple of years?
Sure. Well, the first thing that happened shortly after COVID is the courts all but shut down. Very few hearings. We were we had to start to learn how to do Zoom, and the state Supreme Court waived speedy trial for lengthy periods of time, just waived it, and during that same time, the state was working on getting people out of the prisons, and the county was working on people, and the city were working on getting people out of the jails. And again, there was an uptick, especially in certain types of crimes. Because of that, backlogs were increasing, and prosecution effectiveness overall was down. And the justice system just wasn't operating at anywhere near the capacity that it would need to be able to keep up. And then we lost some people because they moved on to other jobs and that sort of thing. So we had some staffing issues. The police started having some staffing issues because of mandates and that sort of thing. So there were some real challenges in COVID. The good side of that, I guess, is as we emerged out of that period of time, our backlogs are reduced. And I have made sure that we continue to reduce backlogs. We've got some backlog in district court. We've got some backlog in domestic violence. I put out orders to make sure that we're clearing those as fast as we can. We like to be in what they call real-time prosecution. But other counties have much worse backlogs. Similar size counties have much worse backlogs than Spokane County does. But we're very diligent, and we're working towards getting back to real-time as quickly as we can. The staffing issues, not only some of the issues associated with COVID, but county doesn't have the best pay, so people move on to other agencies, and in some cases they can get more money working at Les Schwab or something like that, just working the front desk. So we're challenged by that sort of thing too. We have had significant legislative changes in the last couple of years, as you know. I've alluded to it already a couple of times, and again, the police have lost some tools and some abilities. Prosecutors are losing some tools as well. Sentencing, there's movements in the state, and I was telling somebody recently that there's movement in the state to get rid of life without parole, even for aggravated murder. And there's some people that say 25 years, 20 years, even 15 years should be the maximum sentence allowed in the state. The legislature controls that, as you know, and of course the courts have their say as well. But those sorts of things make it challenging for us to hold people fully accountable. And victims deserve justice, and victims deserve finality, and victims deserve to be made as much as we can whole, or the victim families to the extent that we can. And anything that hinders police or hinders us in sentencing or prosecution poses significant challenges to the constitutional rights of victims that exist in this state.
The the only thing that prohibits people from committing crime is deterrence. So when you tell someone who has been a lifelong criminal and who has done years and years and years and years for whatever variety of crimes you've done, that, hey, you're only going to do 15 years if you go out and violently kill someone or murder in the second degree or whatever the charge would be, then what's stopping them doing that? I mean, it's like when we stopped, and this is a very old school example, but when we stopped cutting off thieves' hands, thievery increased. That's the point I'm trying to make. So if you tell people that, hey, if it's not premeditated murder, yada, 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 you're only going to get 15 years. Well, okay, then you have to prove premeditation, which can
Correct.
be difficult sometimes. So then who's to say that people that the murder rate won't increase?
Yeah.
And in fact, it's funny because I heard you say that and I thought, man, that sounds a lot like England. It sounds a lot like Canada. Mm-hmm. People go out and they commit second and third degree murder. Or they murdered someone during an assault, maybe unintentionally, but they murdered them, and they get 12 and a half to 15. Well, they get 15, but they serve 12. And how is that justice for the family who lost someone forever, and now this person only has to serve 12 years in prison?
Yeah. Well, the legislature and legislature of many states have fallen into the illusion that we mass incarcerate. And I looked into the statistics in Washington. We incarcerated one of the lowest levels of the 50 states. There's about 7.75 million people in the state of Washington, and the actual DOC population is around 14,000. And if you do the math on that, it comes out to like 0.0018. It's
percent of the Spokane County population?
No, the state.
The state population.
State
okay,
population.
Okay.
So if that's mass incarceration, when I think of mass incarceration, I'm thinking on something like a quarter or a third or a half of a population of people. But we are so far under that. And then, of course, there was a popular myth that was put forward for a while that, and most of those people are just in there for minor drug offenses. Well, that's not a true narrative either. The truth is that the people that do remain in the Department of Corrections are some of the most serious violent offenders that exist in the state.
That ought to be there.
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 You said something earlier, and I just want to circle back on this. When we first started talking about some of the challenges you faced in the past couple of years, you said that the state waived the right to a speedy trial.
The court.
The court did?
The court, yeah.
Is that constitutional?
Oh, yeah, sure. Yeah, it is, because the Constitution doesn't define what a speedy trial is. So you will find this. It varies from state to state. Even in, let's throw COVID out of the question here for a minute. Yeah. But in different states, speedy trial is implemented. In Washington, it's implemented by a court rule. And what they decided, and this comes through, these are promulgated by the state Supreme Court with a committee and a lot of inputs and that sort of thing, that if you're held in custody, it's 60 days from arraignment to the end of your speedy trial. If you're out of custody, it's 90 days. That's not consistent across the whole country because the Constitution doesn't define what a speedy trial is. What the goal, of course, was to stop the then popular procedure of holding people basically indefinitely in other countries. And when they put the Bill of Rights together, they wanted to make sure that people didn't languish in a jail cell, maybe not even having been charged. But the speedy trial in Washington is implemented via the constitutional right to a speedy trial is implemented through a court rule, and it actually varies from state to state. I was down in Arizona. Their speedy trial is a little bit different than ours, but it's still pretty speedy relative to the evil that they were trying to prevent.
Right. And because if you go back to the 1600s, you can't just go, off to the tower, and they're there for 20 years, and people think they're dead, and then all of a sudden they come out and they're 20 years old, and it's, oh, you're not dead? It's like, hey, nice to see you, Tim. And it's like, so I do understand that. So so do you think that the Constitution is intentionally does not define, so it can then pass that power to the states? Is that what the intent was in your understanding?
Yes, I would say yes, and the reason I say that is when the Constitution is very specific, there's other areas where it's not. So clearly, there's some judgment that's allowed to be involved in that.
Right.
And so I believe that's why they didn't set a specific time frame.
Right. So there's one last question, and then I'll let you go. So I've always wondered. So there is the speculation that prosecutors careers are made on incarceration rates, prosecutorial rates, and so on. And the reason I bring this up is earlier you mentioned prosecutorial rates were down and so on, relative to COVID and so on. Is there a pressure? Is there a pressure in the prosecutorial world for you to maintain prosecutorial rates? Is there an outward pressure, like not from a social pressure, but from whether it's law enforcement, whether it's the legislature? Is there an outward pressure pushing in on prosecutorial officers to have prosecutorial rates, and you must get a conviction?
No,
there is not. And
I don't feel that at all. In fact, there's rules that we live by as prosecutors that actually say it's not about just getting a conviction. It's about doing justice. Mm-hmm. It's about making sure, and I tell people this all the time. I say, do you know who is more concerned about the constitutional rights of the accused than the prosecutor? Mm-hmm. And I say, no one. Because that's part of our job too, is to make sure that everybody gets a fair trial. Right. And that the rules are followed, that the police follow the rules, that the judge follows the rules, and importantly, that the prosecutors follow the rules. That is what sustains the integrity of the system. I feel no pressure to get a conviction. I feel no pressure to prosecute at a certain rate, at least upwards. Right. I get a lot of heat from local media that we're prosecuting too many cases and that I need to be more like King County. Well, King County a few years ago was posting a 42% decline rate, which means if you're a police detective, a sheriff, a municipality, whatever, and it's a felony, the chances of you getting a case filed in King County were not a whole lot better than a coin toss. So I did a little bit of research looking back into the history of Spokane County, even well before I was elected, and the decline rate was running about 14%. So that means that 86% historically of the felony referrals that come over to the prosecutor's office, like I said, even before my time, are being prosecuted. But we have no built-in pressure to bend or ignore anything just to get a conviction. That is absolutely taboo. That is absolutely not what we're all about. We're there to make sure that justice is done, not only for the victim and the victim's family, but also for the accused, to make sure that they get procedural justice and to make sure that thereby that hard work that went into that investigation and the prosecution process and the judicial process via the trial will be upheld at the Court of Appeals as everybody having done it the right way. Right. And therefore, unless the conviction were to fail on like a jury question or something like that, a jury issue, that everybody else has done their job. My goal is to make sure my people do it right. And whatever happens after that, we can't control that.
That's in the hands of the law, so to speak.
Exactly.
Right. And it's just, I've just heard, you hear these stories of the prosecutor was hungry, and you hear these things and say, well, what does that mean? I mean, I don't, I really have wondered, what does that mean? What does it mean if you have a hungry prosecutor? Or sometimes you hear, the assistant DA was hungry because they had political ambitions or whatever it may be in bigger cities and so on. So I just wondered, the question just came as we were chatting. I just thought, is this a myth? Is it truly as prevalent as what I think people think it is? Because I've had this in conversation with many different people over time.
Yeah.
Where like, they're just, the prosecutor's just hungry, or the junior prosecutor is hungry because they're gunning for the prosecutor's job and so on.
Yeah.
And I'd like to think that as someone who is well versed in the law, that person, whoever they may be, would not do that. And I don't think we see that a lot. There are obviously individual circumstances where you see these things happen, but I don't think it's prevalent and widespread like some people tend to believe. So.
Well, we certainly do not condone that sort of thing in this jurisdiction.
Right. And I think in Spokane County, I mean, I was just talking to John Knowles, and one of the things we touched on was that it seems that in Spokane County, people are pretty well grounded, and people believe in property rights. People believe in law enforcement. People believe in the justice system, mostly overwhelmingly, and that we do have a very good community in Spokane that props up the system, that says, okay, it might not be perfect, but we have what we have, and we want it to work to the best of its ability. And everyone plays a role in that. And so I wanted to thank you for coming on and speaking with us, and I wish you the best of luck in your campaign. Can you just let people know where to find you, how to get in contact with you if they have any questions?
Sure, absolutely. My website is www.votehaskell.com. My email associated with the campaign is larry@votehaskell.com. And I check it regularly, and I'm responsive, and would love for people to visit the site and get a feel for what's on there, endorse if they want to see me back again at the end of the year, and if they want to get, like you said, a little bit educated on the system, or they have a question about how it works, or what is prosecutorial discretion, what does it mean to you, and that sort of thing. We kind of touched on it with just the last subject area, because that involves the proper use of the discretion that's granted to us by the statute. And I look forward to having future conversations with anybody that would like to talk.
Great.
And I'm all about respectful, mutual discussion, and you'll never see me angry. I'll always be straightforward and show you the documents and or the sources of the information that I speak from.
Yeah. Even if you disagree, just be cordial.
Exactly right. That's what makes America great.
It is. So votehaskell.com. Get in touch with Larry if you have any questions. Thanks, Larry.
Thank you.